Dr. S. G. V. Subramaniam is currently working as professor in the Environmental Studies Department of Anna University, Chennai. He has done 8 master's degrees including MBA, 6 postgraduate diplomas, a degree in law and Doctor of Philosophy in the field of environmental management and environmental law. He has done his postdoctoral work in France under the Indo-French Cultural Exchange Fellowship and at Germany under the DAD Fellowship. He has been awarded UN Fellowship and done diploma in international lawmaking and diplomacy from the University of Joensuu, Finland. He is involved in several environmental impact assessment related consultancy works. He has guided several students for their master's degree program project works. To his credit, nearly 77 papers have been published and presented in various national and international conferences. He has been nominated by His Excellency Governor of Tamil Nadu as Senate member for 2 terms to the Tamil Nadu Dr. Ambedkar Law University. He has been nominated as expert member for the State Environmental Appraisal Committee for 2 terms by the Government of India. He has served as member board of studies in the Legal Studies Department of University of Madras. Right now, he has been nominated as member board of studies in the field of environmental studies in the Tiruvallur University. He has written several chapters in the leading books in the field of environmental law.
Welcome to the UGC lecture series on environmental science. Today, we are going to discuss on the National Green Tribunal Act 2010. The contents which we are going to discuss now are the following. The first one, the present adjudicatory framework with reference to environment related cases, recommendation of the Law Commission, then rationale for the constitution of National Green Tribunal, objectives and establishment of the National Green Tribunal, composition of the NGT, qualification of appointment to the post of expert member and judicial member, then original jurisdiction of the National Green Tribunal, appellate jurisdiction of the National Green Tribunal, application to the tribunal, powers and procedure, then bar of jurisdiction. All these things we will be discussing in this episode. The first one, what is the existing framework or the existing adjudicatory framework? The Civil Procedure Code remedying the public wrong by civil courts, applying the principle of strict liability. Second one, Criminal Procedure Code CRPC granting injunction against the public nuisance by executive magistrates. Third one, criminal prosecution before the judicial magistrate under the various laws. Then fourth one, appellate authorities provisioned in some statutes to hear the appeals against the order of the state pollution control boards. This is the existing adjudicatory framework. The National Green Tribunal Act has been first enacted in the 1995. The Act provides for strict liability for the damages caused by the accidents occurring while handling the hazardous substances and to provide relief and compensation to the victims. The Act, however, could not be enforced due to limited mandate. Here, the first time in the year 1995, the National Environmental Tribunal Act was enacted. This Act has provided strict liability only for the damages caused by the accident occurring during the handling of hazardous substances. So, it was very much limited at the time. Now, here I would like to explain what is a strict liability. Strict liability is giving some exceptions. After that, in India, we come across after the Supreme Court judgment in the oleum gas leakage MC Mehta versus Union of India case, we were following the absolute liability. In the case of strict liability, there are certain exceptions are given. Number one, if it is an act of God, again the company is not liable to pay the compensation. It is due to the act of terrorist, or if the act is due to the act of enemy countries, then all the precautions have been taken, duly taken care. In spite of that, some persons due to his mischievous activity, some accident has occurred means, again the company need not pay, the company need not liable to pay the compensation. Like that, there are certain exceptional clauses are available in the case of strict liability. Whereas in the case of absolute liability, There is no exception at all. Now, the National Environment Appellate Authority 1997, this act provides a judicial forum for hearing the appeals against the order of grant of environmental clearances under the EP Act 1986. Again, the National Environment Appellate Authority Act, it was enacted in the 1997. This act was also limited in nature. If any of the industry or if the party is aggrieved by the order of the State Pollution Control Board or the Central Pollution Control Board or the Ministry of Environment and Forest in giving the clearance to the particular project, then they can make an appeal under the EP Act, make an appeal under the Environmental Appellate Authority Act of 1997. Then we are having, of course, the basic remedies available, which is very much available under the Constitution, namely the constitutional remedies under the Article 32 and under the Article 226 of the Constitution of India. Article 32 is the writ jurisdiction of the Supreme Court. Article 226 is the writ jurisdiction of the High Court. Of course, everyone knows what is a writ. Whenever the fundamental rights of the citizens is being affected, he is getting one more right under the Article 32 and 226 to approach the highest judiciary and getting back his right. So, this is the writ jurisdiction. Writ jurisdiction of the Supreme Court, Article 32, High Court, Article 226. Then dimensions of the challenge. Pressures on the environment due to economic development, infrastructural growth, urbanization and changing of the lifestyle. All these things have added pressure to our environment. Then promoting intersectorality and integrating safety, health and environmental concerns. Third one, balancing the environment and development. See, we need the development, we need the environment. So, we have to blend properly the environment and development. There only the question of sustainable development comes. Then again the question comes, how far it is a sustainable one. Then again, here only the dimensions of the challenge, one more dimension of the challenge is arisen. Strengthening and implementation of the compliance mechanism. Then the fourth one, institutional reform in adjudicatory system to keep pace with the implementation of the environmental legislations. Then the adjudicatory system have to be strengthened. That is a proverb, justice delayed is justice denied. We have to give the access of justice and the justice delivery system must be quick. Then Supreme Court directive to constitute the environmental courts. First one, the concept originated from Supreme Court judgment in the oleum gas leakage case in the year 1986. That is MC Mehta versus Union of India case. Then again, in the Indian Council for Enviro Legal Action versus Union of India in the year 1996, again the Supreme Court is of the opinion to constitute the environmental courts. Again, the AP Pollution Control Board, Andhra Pradesh Pollution Control Board versus MV Naidu in the year 1999, it has been strengthened and reinforced by the Supreme Court to constitute special bench in order to dispose the environmental related cases at the earliest. Again, the Supreme Court in the year 2000 requested the Law Commission of India to consider the constitution of a specialized courts in view of inadequacy of the constitution of the appellate authorities, which neither have judges nor the assistance of the experts. This is very much reinforced in the case AP Pollution Control Board versus MV Naidu 2001. See, in the year 2000, the Supreme Court requested the Law Commission of India to consider the constitution of the specialized courts because environment related cases are very special in nature. It is not unlike the other cases because here there are lot of science, engineering and technology are involved. So again, the judge who is hearing the case have to be qualified in all the three fields in addition to that law also. Then what was the recommendation of the Law Commission? In the 186th report of the Law Commission, again it has also stressed the need to constitute the environmental courts due to multidisciplinary issues relating to the protection of environment. This is what I have just told you, that environment related cases are very complex one, very complicated one. It involves science, engineering and technology together with the legal question. Then to have members with the judicial or legal experience assisted by the technical experts. Environmental courts in each state or group of the states. Then environmental courts to have original jurisdiction in all civil cases where a substantial question of law is involved. Then appellate jurisdiction under the various statutes. What was the existing legislative framework with reference to the environmental acts? The Water Act 1974, Water Prevention and Control of Pollution Cess Act 1977, Forest Conservation Act 1980, then again the Air Act 1981, Environmental Protection Act 1986, Public Liability Insurance Act 1991, the National Environmental Tribunal Act 1995, then the National Environmental Appellate Authority Act 1997, the Biological Diversity Act 2002. Now, these two acts, namely the National Environmental Tribunal Act 1995, the National Environmental Appellate Authority Act 1997 have been repealed because of the enactment of the National Green Tribunal Act in the year 2010. What is the rationale behind the National Green Tribunal Act of 2010? What was the reason for constituting the national level Green Tribunal? First one, there is an increasing in the complexity of the environmental litigation. Both qualitatively and quantitatively it has substantially increased. Then frequent need to seek the assistance of the environmental experts. I have already told you that environmental related cases are very complicated. Again, it is not only the legal question involved, it involves a multidisciplinary approach with science, engineering and technology. Then third one, mounting of pendency of lot of cases in the courts with reference to the environment. Fourth one, lack of dedicated jurisdiction. Fifth one, rigidity of existing court procedures to deal with the environmental cases. It is needless to say, when a matter goes to the respective court means we have to strictly follow the civil procedure code. So, when you are following those procedure code means again this process or the procedure will be a very cumbersome only. Non-enforcement of the National Environmental Tribunal Act 1995. Even though it was enacted in the year 1995, it was not fully enforced. Then to maintain the proper balance between the sustainable development and the environmental regulations. Finally, access to the justice. I have already told you, justice delayed is justice denied. So, every person should have the access of justice and the justice delivery system must also be quick. What was the objective in constituting the National Green Tribunal? To provide for the establishment of a National Green Tribunal. Second one, for the effective and expeditious disposal of the cases relating to environmental protection and conservation of forest and other natural resources. Third one, including the enforcement of any legal right relating to environment, and finally, giving relief and compensation for the damages to the persons and property. Here I would like to say a few words about what is a tribunal. A tribunal is nothing but the administrative extension doing the quasi-judicial function. To quote the other examples for the tribunal, for example, this Customs Tribunal, Central Excise Tribunal, State Administrative Tribunal, CAT, Central Administrative Tribunal, Income Tax Tribunal. Again, the tribunals are also having that appellate jurisdiction. They are called appellate tribunal. To quote examples like Income Tax Appellate Tribunal, then Customs Appellate Tribunal, like Railway Rates Tribunal, like that we are having the several tribunals. Certain tribunals are permanent in nature, certain tribunals are temporary in nature in order to get relief for certain cases. For example, the Kaveri Tribunal, it was tentatively created in order to have that disposal of the cases with reference to the Kaveri dispute. Whereas the Customs Tribunal or the Central Excise Tribunal or the Income Tax Tribunal or even the National Green Tribunal with reference to the environment related cases are of permanent in nature. They were all created or they were all enacted under the Tribunal Act. Right. What is the establishment of the negotiation? NGT to be set up by the central government. See, again, since it is happened to be at the national jurisdiction, it has to be created only by the central government. Second one, NGT shall sit at such places and shall have territorial jurisdiction as may be specified by the central government. So, the central government is empowered to make the National Green Tribunal to sit at such places where it is very much warranted or very much wanted. Then secondly, that is the territorial jurisdiction is being fixed by the central government. Second one, it may be specified by the central government. It shall follow the circuit approach also. Sometimes the tribunal may have a permanent jurisdiction, sometimes it will be having a circuitous one. Then next one, central government in consultation with the chairperson to make rules regarding the procedure to be followed by NGT for hearing the matters, the number of judicial and expert members to hear the cases, etc. So, central government in consultation with the chairperson of the National Green Tribunal can make the rules regarding the procedure to be followed by the NGT, and secondly, the number of judicial and expert members to be in that bench, it will be decided. Composition of National Green Tribunal. It shall have a full-time chairperson and not less than 10 and not more than 20 full-time judicial members and not less than 10 and not more than 20 full-time expert members. Chairperson may invite one or more experts from outside having specialized knowledge to assist the tribunal in a particular case. It will go case by case. Chairperson to be appointed by the central government in consultation with the Chief Justice of India, and the judicial and expert members are to be appointed on the recommendation of the selection committee. What are the qualifications required for the appointments of the judicial member and the expert member and the chairperson? First one, as far as the chairperson is concerned, a person who is or has been a judge of the Supreme Court or the Chief Justice of a High Court. Then regarding the judicial member, a person who is or has been a judge of a High Court. Expert member, qualification and experience in relevant scientific and technological field or practical experience in dealing with the environmental matters. What is the terms of the office? Chairperson or the judicial expert member shall be appointed for a period of 5 years. Chairperson or the judicial member, if judge of the Supreme Court, shall not hold office after the age of 70 years. Chairperson and judicial member, if judge of the High Court, shall not hold office after the attaining of 67 years. Expert members shall not hold office after the age of 65 years. Then coming to the original jurisdiction of the National Green Tribunal. The tribunal shall have jurisdiction in all civil cases where a substantial question relating to environment is involved and such question arises out of implementation of the enactments specified in Schedule 1 appended in the NGT Act. The tribunal shall settle disputes provided relief and compensation and may order restitution of the damage of the environment. Schedule 1 with reference to the Water Act, then Water Cess Act, Forest Conservation Act, Air Act, EP Act, Public Liability Insurance Act and the Biological Diversity Act. What is the substantial question relating to environment? As defined in the Act, it includes an instance where there is a direct violation of a specific statutory environmental obligation whereby the community at large is affected or likely to be affected by the environmental consequences. The gravity of the damage to the environment or the property is substantial, or the damage to public health is broadly measurable. The environmental consequences related to specific activity are point source of pollution. Right. The next one with reference to the appeal, that is that appellate jurisdiction of the NGT. appeal may be preferred before the NGT against any order of the appellate authority under section 28 of the Water Act, order of the state government under the 29 section of the Water Act 1974, directions by the State Pollution Control Board under section 33A of the Water Act 1974, then decision of the appellate authority under section 13 of the Water Cess Act 1977, then order of the state government under the section 2 of the Forest Conservation Act 1980. So, in all these sections, whatever that order given by the respective authorities, if the order, because of this order, if the party is aggrieved, then it has got every right to approach the National Green Tribunal, and the National Green Tribunal has got the appellate jurisdiction. Order of the appellate authority under section 31 of the Air Act 1981, under section 5 of the Environmental Protection Act 1986, the grant or refusal of the environmental clearance under the Environmental Protection Act 1986, order or determination of the benefit sharing made by the National Biodiversity Authority, State Biodiversity Authority or the board under the Biological Diversity Act 2002. Then the corresponding amendments in the relevant acts have been provided in section 36 as per the schedule 3, so as to enable the provisions of hearing the appeals in the respective statutes. Then award for the relief of compensation and restitution of the damaged environment. The tribunal may by order provide a relief and compensation to the victims of the pollution for the environmental damage arising under the enactment specified in the schedule 1, including the accident when or while handling any hazardous substances. Number 2, restitution of the property damaged. Third one, restitution of the environment of the areas as the tribunal may think fit. Then what are the limitations of the filing of applications on the head of claiming the relief and compensation? Application for relief and compensation or restitution to be made within 5 years from the date on which the cause of such compensation or relief first arose. Then compensation of relief payable under the heads specified under the schedule 2. Heads of compensation relief: death, permanent or temporary disability or injury, loss of wages, then medical expenses, damage to private property, damage to the public property, then expenses incurred by the government, local authorities in providing the relief and rehabilitation to the affected persons. Then heads of relief continuation: compensation for environmental degradation and restoration of the quality of the environment, claim on account of the damage or the destruction of the flora, fauna, crops, vegetables, trees, orchards, etc. Then loss of business or employment or both, and any other claim arising out of any activity of handling hazardous substances. How to make the application to the tribunal? An application for the settlement of the dispute or relief or compensation may be made by the person who has sustained the injury, or the owner of the damaged property, or the legal representative of the deceased, or any agent who is duly authorized by the person affected, or any person aggrieved, including the representative body of the organization, the government, Central Pollution Control Board, State Pollution Control Boards, then PCCs, or any environmental authority constituted or established under the Environmental Protection Act, or any other law for the time being in force. The application or appeal to be decided expeditiously after hearing the parties within a period of 6 months from the date of the filing of the application for the appeal. Then what is the power and procedure of the National Green Tribunal? NGT is not bound by the procedure laid down by the CPC, that is Civil Procedure Code. It does not have any binding on the National Green Tribunal, but it has to be guided by the principles of the natural justice. The principles of the natural justice is nothing but giving the due opportunity of being heard. Second one, NGT shall have the power to regulate its own procedure and not be bound by Indian Evidences Act. See here the difference. If any criminal matter goes before the court of law, we have to follow the Indian Evidences Act 1872. But here the National Green Tribunal is not bound by the Indian Evidences Act, but of course it is bound by the principles of the natural justice. I have already told you, given the due opportunity of the being heard, that's first one. Second one, giving all the evidences, whatever that evidences are, the witnesses which are countered against the party, that this party must be given the due opportunity of seeing all the evidences and examining the witnesses, cross-examining the witnesses, re-examining the witnesses. All these things are very much conferred under the principles of the natural justice. NGT shall exercise powers of a civil court in respect of summoning, enforcing the attendance, examining on oath, receiving evidence on affidavits, deciding matters ex parte, etc., and power to grant interim orders or injunctions or stay. It is as equal to as a civil court. It has got every power to summon the person, enforcing his attendance, then examining on oath, then receiving the evidence. But of course, it is not totally bound by the Indian Evidences Act, receiving the evidence on the affidavits, then deciding the matters on ex parte. The party who is not turned up means, again the tribunal has got every power to give the justice on, to give the case on the ex parte, or the tribunal has got every power to decide the case on ex parte, and power to grant interim orders, injunctions or the stay orders. NGT have to follow certain principles in the deciding or in the decision of the cases. First one, the principle of the sustainable development. Second one, the precautionary principle. And third one, polluter pays principle. All these principles have been developed by the active judiciary, or the judicial activism has played a substantial role for the emergence of environmental jurisprudence. And one such most important thing is supposed to be the principle of sustainable development. An offshoot of the sustainable development is the precautionary principle, polluter pays principle, of course even we can say the absolute liability also. Then orders of the NGT appeal to the Supreme Court. Civil court to execute the order or award made by the NGT. That NGT has given that order means it is as equivalent as the civil court giving that order. It has to be executed, both letter and spirit. Any payment or the deposit amount directed by the NGT as award shall be recoverable as arrears of the land revenue, just like the civil cases. Then award or order by the NGT shall be executable as a decree of the civil court. That is, the decree means order of the civil court. Then decision taken by the NGT by majority shall be binding. Then NGT may award cost for filing the false and vexatious claims. If the claims are out to be false means it can induce the punishment also, it can impose certain fines also on the petitioner. Persons aggrieved against the order of the NGT may prefer an appeal to the Supreme Court within 90 days. I have already told you that NGT is functioning under the jurisdiction of the Supreme Court. If any person aggrieved by the order of the NGT, he can make an appeal, or if there is any substantial question of law is involved, he can make an appeal to the Supreme Court within 90 days of the order given by the National Green Tribunal. Penalty for the non-compliance of the order of the NGT. First, punishable with the imprisonment of 3 years or with a fine not exceeding even 10 crore of rupees. Then non-compliance continues, an additional fine of rupees 25,000 per day during the period of contravention continues. For companies, fine may extend to 25 crores. You see how much enormous amount. If non-compliance continues, additional fine of rupees 1 lakh per day during the period of contravention continues. Again, there is certain bar of jurisdiction. First one, civil courts are debarred to entertain the disputes regarding any claim for granting the relief, because NGT is given full power. So, the power of the civil court is debarred, or the power of the civil court is being taken away by the National Green Tribunal Act. Second one, no injunction can be granted by any civil court in respect of any action or order of the NGT. For example, the NGT is given an order. You cannot approach the civil court to obtain any order of the NGT, or the civil court does not have any jurisdiction in granting any injunction or any stay for the order which is given by the NGT. The civil court jurisdiction is debarred to hear the appeals in such cases where the decisions of the authorities are appealable before the NGT. Civil court jurisdiction is debarred to hear the appeals, that is, that appeal should not be heard by the civil court. Then the decision of the authorities appealable before the NGT. Repeal and savings. National Green Tribunal Act 1995 have been repealed. Then National Environmental Appellate Authority 1997 have also been repealed. The functions of the National Environmental Appellate Authority to be subsumed in the NGT, and pending appeals shall be transferred to the NGT. Then what are the expected improvements we got because of the constitution of the NGT? That NGT shall have the judicial and scientific experts. NGT ensure a speedy disposal of the environmental cases, flexibility in the procedure. Then aggrieved person can file a case before the NGT to ensure greater access to justice, and NGT ensure timely relief and compensation to the victims in addition to the Public Liability Insurance Act. It addresses the lack of environmental appellate provisions under the EP Act and Forest Conservation Act. Unlike NEAA, National Environmental Appellate Authority Act, and NGT shall also hear the appeals against the refusal to grant environmental clearances, provides second tier appeal under the certain legislations, appellate jurisdiction of the High Court under the Biological Diversity Act transferred to NGT, reduction of the burden of on the High Courts. In summary, what we have discussed: number one, existing adjudication framework with reference to NGT. Then what are the objectives of establishing the NGT? Then what is the qualification for the members of the NGT? Then original and appellate jurisdiction of the NGT. Then what is the powers and procedures of the NGT? Now let us move to the questions. First one, what is the rationale in enacting the NGT Act in the year 2010? Write the establishment of the NGT. What is the composition of the NGT? Write the qualifications of judicial and expert member of the NGT. What is the original jurisdiction of the NGT? What is the appellate jurisdiction of the NGT? Thank you very much.